Like, even if you want a camera
Oh.
for your business, the same.
I'm a photographer. I'm okay with that.
You're a photographer?
Yeah.
And you still use an iPhone?
Because of that, actually.
Really?
My equipment is everything, so to change that is great.
We are live, so I was talking here about Apple and all that stuff. Best cameras. See?
Okay, sure.
So far, he's been agreeing on so many things. The only issue was, I don't know where the apps are.
No, it just takes a while.
Anyway. Could you raise your hand if you have an iPhone? iPhone. Who still has an iPhone? Hello, what you have?
Motorola, Android.
Those exist? Motorola's still around?
You still got a couple.
I'm just kidding. Because now it's just the hype is between Samsung
Oh,
and
that can coming
iPhones.
out with a new phone too. Cool.
Yeah, Motorola's, I know, I'm just messing with all. There's a cool phone right now, OnePlus. It's like half the price,
yeah,
and it
yeah,
has almost,
Similar to the Samsung.
yeah.
And yours?
I'm sorry?
The cell.
My cell phone?
Yeah, US.
I what? No. There's no I here. For I is me. That's it. Samsung. Hands down. Best. Anyway, preparation of documents. New Jersey allows brokers or their agents to complete residential leases and standard approved sales contracts for 1 to 4 family residents and single vacant lots. So we talked about this in the first chapters, right? We can prepare contracts 1 to 4 or vacant single lots. Anything above that is commercial or unique. Attorneys prepare those contracts. So to avoid the unauthorized practice of law, brokers and their salespersons may not, so circle may not, draft commercial leases, option agreements, or sales contracts on tracts of vacant land, commercial property, or industrial property. Next, New Jersey requirements.
Question. So hypothetically, if we have
I'm going to change your name to hypothetical.
if we have like a friend that already drafted, a lawyer friend that already drafted a contract for commercial units or stuff of
Nope,
that.
cannot use it.
magnitude,
What
we
if
can't
you were?
just change the address and use the same
Nope.
one?
That's what the 1 to 4 family contracts are. They're standard contracts already drafted. All you have to do is fill in the blanks. Commercial, they're completely unique. Attorneys have to prepare for each transaction. You cannot copy paste, you cannot change addresses, no. 1 to 4 family, that's what it is. It is already a standard contract prepared. Okay. So, New Jersey requirements says all offers, contracts, or leases prepared by licensees must indicate the business relationship that the firm has with respect to the parties named in the documents. Where do we find, guys, where do we find the types of business relationships we can enter into? Which document?
It's the one that we folded right here
Mm-hmm.
at the bottom.
Page.
On page 35.
The one you guys read, right?
Correct.
Page 34, page 35. Write it down again.
Almost. Let's explain.
Almost. Ready? All right. Next it says, attached to a proposed contract of sale as a cover must be the notice that is included on the first page of figure 11.1. We'll get there in a second. appropriately revised if the broker represents the buyer or is functioning as a dual agent or as a transaction broker. Because that's what we find in the CIS. Seller's agent, buyer's agent, disclosure agent, or transaction broker. And it's very, very important that the buyer and the seller are fully informed of how you're representing either or. Okay? Because the broker agent has a monetary interest in the transaction, the buyer could void the contract if this fact is not disclosed. Right? Because offer and acceptance, meeting of the minds, is not there. For offer acceptance to exist, all the terms must be clearly understood by all parties. Okay? Next, New Jersey also requires that the following language appear in exactly this form at the top of the first page of a sales contract. And it says, this is a legally binding contract, and you will become final within 3 business days. Three business days. Victor, have you ever tried dropping your phone?
Drop you? Well, not tried, but yeah, I have dropped it. Oh my god.
That's another thing I forgot. They shatter real quick. All right, so 3 business days, binding. What does that mean? It means that within the 3 business days, you have the right here to consult an attorney who can review and cancel the contract. That's the attorney review. They will study the contract. They'll start counting the time from the moment that both parties received a delivery of signed contract. So once the seller signs a contract and that copy goes to the buyer, now we have an agreement. 3 business days start ticking now. Now, what is the 3 business days? It means that the attorney can issue a notice of disapproval within 3 business days. If no notice of disapproval is issued within 3 business days, then the contract is binding. If a notice of disapproval is issued, then we start bouncing back and forth. It could take 3 days, it could take a week, it could take 2 weeks until we go to final agreement. But any dispute must be started within 3 business days. You okay, listen? Look up. Do you see the spider up there? It helps. If you look up, spider. You went to the wrong hole or just coughing?
Yeah, I went to the wrong.
Okay, then look. Spider, right up there. Always works. Tell me. Nobody listens to me. But it works. When you look up, it opens all this. Okay. You got kids, you know what to do. All right, the state also requires an equivalent notice on leases, that it's a legally binding contract. And then there's other required disclosures. For instance, off-site conditions, right? Lead-based paint, and Megan's Law disclosures. These are considered part of the contract. Next, I'm sure you guys remember this, federal requirement. If the property was built before 1978, say it louder, hello? Hypothetically, or you have to? Sorry, just want to miss it here. You have to check for lead. No, we don't have to, but the buyer must be offered the opportunity to. We don't have to. In fact, the seller is not required to test, but the seller is required to give information if they know of lead-based paint. The buyer must be given a 10-day window to inspect for lead-based paint. Simple as that. Next. Now, Ella, you're asking me about what if, hypothetically, a friend of yours is a lawyer, already prepared the contract, as we just change. So, 1 to 4 family contracts, as I was mentioning, They are printed forms prepared by attorneys, and they are standard forms. Because there's so many 1 to 4 family sales, contracts are pretty much the same. For anything above that is unique. We don't find as many 5 families out there, 6, 7, 8. Commercial deals, they're all different from one to the other. So attorneys prepare these. For us, 1 to 4 family, this is what we have. But there's a big problem here. Even if you had something that was a template, issue number 1, what to write in the blanks, right? Issue number 2, what printed matter is not applicable to the particular sale and can be ruled out by drawing lines through the unwanted words. And finally, what additional clauses or agreements called riders are to be added. So if it's already complicated on a 1 to 4 family transaction, imagine when we get to commercial. All right? So these are the problems with contract forms. In addition, all changes and additions usually are initialed by both parties. And if changes are made, the rule is that typing takes precedence over printed forms, and handwriting takes precedence over typed changes. You guys got it? Yes? No? Maybe? Say yes, please.
Yes.
Yes.
Okay, thank you. Simple, just please say yes. If you don't got it, you don't got it. But still say yes. All right. Listing agreements. We covered that in the previous chapter, so just highlight the first sentence. Buyer brokerage agreement. This is chapter 3. We spoke about it, so just highlight the first sentence. Transaction broker and dual agency agreements. We talked about this also in chapter 2 and 3, actually. And you guys remember in chapter 1, I said for you to write NJAC 11.5? You probably don't. It was the very first thing I asked you to do. Is because we're talking about New Jersey Administrative Code, Title 11, Chapter 5, which are the rules and regulations that the Real Estate Commission sets. Okay? And I told you that later on you're going to see NJAC, so make it a reference to this. Page 140, sales contracts. In front of sales contracts, I want you to write offer. In front of sales contracts, I want you to write offer. So whenever somebody asks you, hey, put an offer, what are they telling you to do?
Spruce sales contract.
Prepare a sales contract. In fact, I want you to underline here, it says, depending on the locality, this agreement may take one number of forms and be known as an offer to purchase, contract of purchase and sale, earnest money agreement, binder and deposit receipt, or any other variations of these titles. They all mean the same, which is put an offer. The first time I dealt with real estate and with a realtor, so about 15 years ago, I'm saying, I want this house. He goes, I put an offer. Like, I'm unrepresented. Why are you telling me to put an offer? Why don't you just say, hey, I'll represent you? No, put an offer. Like, I want to give you $350 for this house. Put an offer. Put it in writing. Text message. $350 for the house on, I think it was 26 Merchant Street. Right? He goes like, no, you have to prepare. I'm like, I don't know. If you're the listing agent, why don't you represent me as well as a buyer? I'm okay with it. Just let's get this deal going. Anyway. So he kept on telling me, insisting, like, put it in writing, put it in writing, put it in writing. All he was saying is prepare a contract. Okay? That's how it is. So, next thing we have, offer and acceptance. Everybody knows what offer and acceptance is by now. What I want you to go to is at the bottom, it says counter offer. Do you see it? Right there? Counter offer. Does everybody see this? Great. Where it says counteroffer, says any attempt by the seller to change the terms proposed by the buyer creates a counteroffer. The buyer is relieved of his original offer because the seller has in effect rejected it. So where it says counteroffer, somewhere here, I want you to write rejection. I need you to remember counteroffer equals rejection. So, quick question. Lucy, I'm going to offer you for your house $200,000, but it has to include the drapes because I really like the drapes you have in your house. That's an offer. Lucy over here answers back with, I'll accept you $200,000, no drapes.
It's a counteroffer.
That is in effect a counteroffer. So if I say, well, no deal. Can Lucy come back and say, hey, you know what, let's go back to your original offer, I'm okay? She can. Do I have to accept it?
No.
No, because you rejected my first offer with a counter, just taking the drapes out. You have in effect rejected my offer. Therefore,
There's no deal.
there's no deal. Can I go back? Well, just like the previous one, it's as valid as between the parties. If I choose to proceed and thank you for the drapes, good. But if not, you cannot enforce anything because you rejected my contract.
You
guys
have to
got
make a new contract.
It will have to be a new contract if
You want to
I choose to proceed. You guys got it? Believe me, something as ridiculous as drapes changes the contract, rejects the contract, is a counteroffer. Okay? That was a hint. Maybe in the school exam, maybe in the state exam,
Maybe in both.
maybe both. Yeah. Just look for drapes. Earnest money deposit. Now, where it says earnest money deposits, I want you to write, even though it's written right below, but I want you to write good faith deposits. I want you to write good faith deposit because every time you see earnest money, it's good faith deposit. Okay? Every time you see earnest money, good faith deposit. Now it says it's customary but not essential. Customary but not essential for a purchaser to provide a cash deposit when making an offer to purchase real estate. So it's not mandatory, it's not required that you come up with $1,000 or $10,000 or $20,000 up front, right? It's customary. It's called good faith for a reason. Because I'm telling you guys, I really want to buy in your house, and to show you good faith that I'm really focused on your house, here's X amount of dollars. I'm just trying to assure you, so give you evidence that I'm willing to carry out the terms of the contract. I'm not just putting offers everywhere. I'm putting an offer on your property, and I'm serious about it. That's what it is. Earnest money or good faith. I am acting in good faith when I put this offer. So if you accept it, we'll move forward. Any questions here? No? Great. If you skip to the third paragraph there, it says earnest money. We already talked about earnest money in the previous chapter. And we said that you have to deposit in the escrow account or trust account within
5 business days.
5 business days. So I need you guys to correct right here. Where it says 5 days, I want you to write business. Lucille, you got it?
Yes.
Okay, perfect.
Thank you.
Just want to make sure everybody's there. So where it says 5 days, I want you to correct to 5 business days. And I apologize, there are several instances in the book where they forget the business. So if they forget, I imagine you in the exam. Right? All right. If you keep that money for more than 5 business days, what is that considered?
Oh,
Chinese word?
um,
Chinese word?
Commingle.
Commingling. Commingling. Okay? Simple. A broker may not use such funds. So one thing is keeping it, the other thing is using it. If you use it, this illegal act is now known as conversion. Okay? So holding on to the money or mixing the money is already bad. That's commingling. Using the money for personal use is now conversion. And that's where a lot of brokers lose their licenses. So if you ever go to the real estate commission and you look for, problems that brokers and salespeople have, because there's a list, you can go search all complaints. One of them, or the majority of them, are because of this, commingling or conversion. It's tempting. Sometimes we might have $200,000-$300,000 in the escrow account, maybe even more, at one time. It's tempting. It takes 3 months for us to close, so you don't touch that money until then. Yeah, how many houses can I buy in between? And I'll put the money back, don't worry. Any cash deposit of more than $10,000 must be reported to who? The IRS. We already know this, so I'm just skipping a few things that we already talked about. Now here, page 141. This is the notice that's very similar to the CIS. See, the CIS was simply a disclosure. Also a notice. The difference between the CIS in the beginning and this notice now is that with the CIS, I'm telling you, hey, I intend to work with you as a transaction broker, or I intend to work with you as a seller's agent or a buyer's agent or something like that, right? The notice now says, as a real estate broker, I represent. It's not I intend to. No, it's I represent now. The seller or the buyer as the buyer, not the seller, both the seller and the buyer, or neither the seller nor the buyer. So this is the moment I'm actually telling you how we are related. What's our business relationship? CIS, heads up, this is how I could represent you. Contract, it's not a heads up. This is how I'm representing you. You got it?
so this is when you put in an offer?
Yep.
Okay.
And it says right here, it's a notice to read this notice before you sign the contract. Does anybody read? No. So you should read it for them because they have to sign. So this is the contract, the offer. You fill this out, get familiar with it because not for state exam, but right after the state exam, get familiar with it because this is a standard contract that your friend prepared and you have to know how to fill out, okay? There's some stuff here that doesn't apply, real quick, like this one on page 145, lead-based paint, doesn't always apply. Line 201, right? It doesn't always apply because not all properties were built before 1978. Also, if you go to page 146, line 239, right? You don't have a well, not in all cases. So the point of entry treatment is not applicable. The cesspool requirements, not applicable in most properties here. Does that make sense? So there's a few things here that you don't need. You should get familiar so you don't waste time. Radon testing, it talks about infestation, the buyer's rights to inspection. Everything is laid out in the contract. If you're in a flood area, Megan's Law statement's right there. You guys remember that? That's on the line 394. I'm sorry, 388. Off-site conditions says right there. I mean, so many things. Bulk sales, Insurance, maintenance, risk loss, blah, 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 all that good stuff is there. So I don't go through contracts because most of it, we either dealt with it in the first chapters, right? Or in listings, because whatever's in the listing comes here as well, right? But it is very important that you guys know how to fill this out later. Oh, on page 152, look what it says. Line 591. What does it say there?
Disclosure of the buyer, sellers, or real estate licensee.
So if you are a real estate licensee and you're selling or buying your own home, you must disclose. All right? The moment you're licensed, you cannot hide your license. Okay? You don't have to be represented by yourself. You can be represented by somebody else. But you must disclose that as a buyer or seller that you are licensed. Okay? Attorney review clause mentions there, assignments, applicable laws, and look right here. Page 153, we talked about these things, which was addendums. So on line 658, we talk about addendums. For instance, we're going to talk about this in the next page, which is buyer's property sale contingency, condo or homeowner association, FHA or VA loans. These are all addendums because based on whatever we check off, we need to add an additional form that discloses these things. Okay? Addendums, so additional documents or writers, and so on. So I want you to go to page 154. And we're going to skip the bullet points. I want you to highlight where it says the signature of a witness is not essential for a valid contract. It's not that bad of a chapter so far, right? Especially because I'm taking some time here. Contracts is very important. On the right-hand side, it says contingencies. Do you see it? Contingencies. What is a contingency? It's a condition, right? So I want you to write condition. Because in a contingency or condition, I'm telling you, I will buy your house if. Right? If. And what is the contingency? Well, in this case, it says when the purchaser intends to secure an FHA or VA loan, special clauses must be included in the sales contract that provide that the contract may be voided if the property appraises below the sales price. So I'm telling you, I'll buy your house if it appraises. If it doesn't appraise, it makes sense. I'll cancel, right? In fact, if you guys skip to the next paragraph, it says, among common provisions in the subject to means contingencies or conditions. Subject to, I'll buy it subject to, or I'll buy it if, right? It's the purchaser's need to secure a specific loan. If I get approved, then I'll buy. The purchaser's right to a satisfactory report of the property by a licensed home inspector within a specified few days. If the inspection is favorable to what I expect, I'll buy. Approval of the contract by a family member, again, within a specified few days. Hey, if my cat wants it, we'll buy. Right? Cats are family members, right? Dogs. Or the purchasers need to sell a present home before buying the next residence. So look, Ella, I really want to buy your house, but I still have to sell mine first. So here's an offer pending the sale of mine. Does that make sense? So that's the condition or contingency for me buying your house, is that I'm able to sell. If you agree to it, then you have to wait for me to sell mine. Okay? The buyer cannot be required to complete the purchase if any such contingency or condition is not satisfied. Now, Ella, to protect you, the seller, when the purchaser has another home that must be sold first, the seller, so Ella in this case, may insist on an escape clause, also called kick-out or knockout clause. Why? You're not going to wait forever for me to sell my house, right? Doesn't make any sense. So the kick out or escape clause is literally telling me, the buyer, hey, hurry up. Right? L is telling me, I did consider the fact that you're selling your house, but in more than 6 months, I don't know. So it's either you step up or get out. Simple as that. That's the escape clause. Makes more sense now, right?
Normally you give people 6 months.
No, I was just giving an example. It could be less. It's whatever you agree to. You're the one that comes up with that time frame. Okay? Next, we have liquidated damages. Yeah, you took too long in the bathroom, so we're almost done. So liquidated damages. Didn't we talk about this already? Liquidated damages? Say yes. Everybody together say yes.
Yes.
Thank you. So we talked about when the buyer breaches the agreement without legal excuse, the seller has 3 options plus 1. The plus 1 option, which is this one, liquidated damages.
Settlement.
The settlement. The seller has the right to keep the good faith deposit as liquidated damages, as a settlement. Okay? In fact, it says right here at the bottom, the seller who does choose to keep the deposit as liquidated damages may not sue for any further damages. So it's a liquidation. That's it. I'm not looking for more. It's what I got, and we're good to go. Got it? Questions? Going once, going twice. Lucille?
Thank you.
You're welcome.
I just studied.
All right. You can always ask questions. Next, since there's no questions. Plain language requirements. New Jersey law requires that certain written agreements for the sale or lease of residential property be written in clear and coherent manner with words that are common in everyday usage. Remember, we are not required to have an attorney for contracts on residential property, right? So if we're not required to have an attorney, then the contracts must be in plain English, in a way that we can all understand when we're reading it. Correct? So this is a requirement for every single contract. No legalese, no Latin, no nothing like that. Plain, everyday language. Yes?
In case you're dealing with someone who's not good with the language, can you do like, let's say Spanish or some other language contract, or you got to translate the actual English contract and then show it to them in translation? Or?
I would recommend them to have an attorney
Okay.
that speaks their language. As a realtor, at that point, I do speak Spanish, I speak Portuguese, I speak English, I'll speak Italian, French, Chinese, whatever you want me to speak. But when it comes to contract, I recommend you find an attorney that speaks your language.
Okay.
Only because I don't want to be giving you legal advice. Because every time you start translating something, oh, but what you think? Do you think this is right? Do you think this is not right? Yeah, I'm not the attorney. So you'll have to decide that on your own or find an attorney. So especially when it comes to translations of contracts, legal documents, it could be very, could be misinterpreted. Let's put it like that.
Okay.
Okay. Where it says rescission of contract, right above rescission, I want you to write cancellation. Where it says rescission, write cancellation. And we already talked about this in several instances. They have X amount of days to cancel something, right? So 3 business days to cancel a contract, right? We talked about 7 calendar days and 7 business days, depending on what it was. We talked about 5 calendar days for offsite conditions, and so on. And we're still going to address a few more. So the only thing that's here, you guys can read it at a different time. We already went over this. So next thing we have is option agreements. In front of option agreements, I want you to write similar to car lease. similar to car lease. Did we talk about car lease earlier? What did I talk about car lease?
So you can pretty much renting with the option of buying.
Perfect. Option. That's what it is. Are you bound by the contract?
No.
Only if you decide to buy. So just like a car lease, you get to test drive the house, and 3 years later, buy if you want. It could be 1 year later, it could be 5 years later, it could be 10 years later, whatever you guys agree, right, to the terms of the contract. It's rent with option to buy. Simple as that. Questions? No, right? This part is easy. Now it's the complicated one. Everything's been easy so far. Land contracts. In front of land contract, I want you to write similar to car financing. Because car financing, when do you get the title?
When you finish paying it off.
When you finish paying it off. But you get to test drive the car as well. It's not yours until you pay it off. You get to use the car for all these years, pay interest, principal and interest loan, right? So this is technically called, the land contract is also called, please underline, contract for deed or installment sales contract. This is a type of seller financing. And I'll explain more about seller financing in later chapters. Okay? Now, the buyer agrees to give the seller a down payment and pays regular monthly installments of principal and interest over a number of years. The buyer also agrees to pay for real estate taxes, insurance premiums, repairs, upkeep, as if the house was fully yours. And it is. You just don't get the deed until the end. Although the buyer obtains possession when the contract is signed by both parties, the buyer has equitable title. Put a star next to equitable title. And the seller does not execute and deliver the deed to the buyer until the terms of the contract has been satisfied. This frequently occurs when the buyer has made a sufficient number of payments to obtain the mortgage loan and pay off the balance due on a contract. So, similar to car financing. You get in the car, you drive off the lot, you pay the taxes, you pay the insurance, you maintain the car. When do you get the car? At the end, the title, at the end. Same thing.
Can you still sell?
You can do whatever you want. The thing is, you have to satisfy the sale that you have. Okay? So it's a seller financing. Okay? Any questions? No? If there are no questions, summary. We're done. All right?